There's a war on doctors. We know it. Everybody in this room knows it. And what I want to do at the beginning of my talk is introduce to you a legislator here in Texas who is our point man on these issues. And Representative Bill Zedler, standing to my left, is a bulldog for us in the Texas legislature, the House of Representatives. He's on the Public Health Committee, was just appointed on that in the last few days. He is someone who can show up at your ISC hearing, if you get called to an ISC hearing here in Texas. He's someone who can make an open records request. If you're from out of state, he can still let you know what he's doing in Texas, and you can get a legislator out of state to be your point man there. With this war on doctors, we need all the help we can get. And Representative Bill Zedler, who's from the South Tarrant County area, Arlington and so on, is our #1 ally in the Texas legislature. So please give Representative Zedler a warm welcome.
Thank you, Andy, and it's a pleasure to be here with you today. I want to tell you that I came out of the medical industry. I started off as a hospital personnel officer when I was in the military, and then I served, I was with Baxter for 20 years. I was with a couple of venture capitalist companies for a long period of time, and so when I came to the Texas legislature initially, I asked to be put on the Public Health Committee. We started a new session now, and they changed the committees, and they've put me back on the Public Health Committee this time. And I first got involved in this when I had a well-respected physician in the Arlington area who had gotten a letter from the Texas Medical Board, and the letter went like this: "We believe you might be in violation of the standard of care with regard to this patient. Please respond in 30 days. I went over and talked to the physician, and when I did, I found out he was sending a file box full of a response. And the reason why, of course, was because he had to justify every decision he had made from the very first day he saw the patient to the very last day he saw the patient. And I said, well, you know, that doesn't seem quite right. It's kind of like saying to you, you know, you're in violation of the law. We're just not going to tell you what law you violated. And you just tell us what you've been doing for the last couple of years. And so when I started talking to the Texas Medical Board, all of a sudden I found out that this was kind of routine practice for them. And so we've done some things. They actually started changing that line and started specifying, just like every other oversight board does down there. In other words, we have the dental board, chiropractic board, the optometry board, all the others. They're very specific about what you've done wrong, and so it's very easy to respond. And so I said, we need to do like these other boards do. And they actually started changing that without changing the law. But what we've done now is at least make some changes to make sure there's due process. We're going to make some more changes this time. One of the things has to do with secret expert witnesses. And because I've actually had people from the medical board start calling me up. And basically what they've done is they've validated a lot of the things we assumed were going on, but they've confirmed that they are going on. And one of the things is that, you know, the secret expert witnesses are not supposed to have a conflict of interest. Well, guess what? When they're a secret, they can have conflicts of interest. And we found that in some cases, some of the expert witnesses are direct competitors to some of the doctors who've been examined. The other thing is this. We found that, you know, if you don't know who the expert witness is, well, you know, here's the way it's supposed to be. You start off with 2, and if they agree, then it either is, you know, you're told it's dismissed, or it goes on to the ISC. If they disagree, it goes to a 3rd. Okay? So at the most, you're supposed to have 3. Well, what we found out, well, they just go through as many expert witnesses as they need to go to the desired results. And so I've never liked secrecy in government. You know, if that's with the CIA or something like that, that's fine. So the other thing is I'm a firm believer that, you know, cookie cutter programs and approaches are not real good for innovation. And their only way to help us succeed in driving down healthcare costs, getting the best results, is that we have a divergence of ideas and approaches. So that's what we're driving for. I used to be able to say I'm the only Z in the Texas legislature, and then a guy named Zerwas came along and ruined my stick. So, but I'll tell you this, I'm the ZEDLER down there. If you ever need anything, don't hesitate to call me. Again, as Andy said, I will sit in on ISCs in the state of Texas. Don't go to Oklahoma or anywhere else like that. But in the state of Texas, I do, and I do a lot of open records requests. In fact, from these people that had been on the Texas Medical Board and who've left or whatever, they've told me that every time they get one of my open records requests, they just go nuts down there. And so I figure, well, if we can't just get them to quit, we'll just drive them nuts. So I'm glad to be here. Keep up the good work. God bless you guys. Thank you very much.
That was terrific, Bill. Thank you. And just to put that in context, it's pretty scary when you get a letter from the Texas Medical Board or whatever state you're in saying that there's an investigation. And it's very good to know that you have an ally in your state legislature who can come in and start asking questions about what's going on and start monitoring the process. That takes a lot of the fear out of it, and it removes a lot of the mischief that the medical board would engage in if no one were watching from the legislature. Okay, this is a funny looking building we're in here, and I was informed that this used to be a strategic air command during the Vietnam War, during Desert Storm, the Persian Gulf War, and that this was kind of like the Pentagon, except this building was called the Roundagon. And most of it was below ground and were reinforced by all this tons of concrete around us, and they were going to demolish it when they stopped using it for military purposes, but they came in and the hotel took it over. And you can get from the front desk a story about how this was used as a key military location during the Cold War, one of only 3 Cold War locations around the country that were completely reinforced, and where even the president could come here if necessary and go below ground and be protected by all the concrete around us. Well, I think God does have a sense of humor, because that is suitable for the task we have at hand here. There is a war on doctors, and it's coming on many fronts. It's not coming in airplanes and Navy ships, but it's coming in the form of medical boards, and I'll be speaking more about medical boards tonight. But it's perhaps just as much as medical boards is the threat against medicine that's being posed by hospitals today. And that's what I'm going to speak most about, are hospitals, how hospitals are encroaching on the practice of medicine and interfering with doctors, basically coercing doctors either to become employees of the hospital or get off the staff. And we see a number of sham peer reviews that are arising out of this demand by hospitals to control the practice of medicine. Now, I think everyone in the room probably knows what a sham peer review is, but let me just clarify it, as I have to do for the courts, because the courts do not yet know what a sham peer review is, but they're learning. Sham peer review is when a hospital in particular says they're going to do peer review on a doctor to see if the doctor's been doing anything improper, but the thing is a sham from the get-go. The hospital is already determined they want to get rid of the doctor, and there could be a variety of reasons for this. And you'll see a number of different examples in cases we've been involved in. But it's a sham. The peer review is just going through the motions from beginning to end. The hospital knows what it wants to do. The administration has already determined they're going to get rid of this doctor, and they're just going through the procedure to make it look like they're giving the doctor fairness when everybody knows that it's not going to be fair and that the doctor is going to lose his privileges at the end of the day. Many doctors have a problem understanding it and take this personally when a hospital does this to them. And I've helped many doctors who've been victimized by sham peer review, and the physicians will go through the story how they didn't make a mistake, it wasn't their fault, the punishment was way out of proportion to what happened, and they'll tell me the story, and I have to cut them off, and I say, I know that. I know it's a sham. The administrators know it's a sham. Everybody knows it's a sham. They were just looking for something to get you on. You may not have even been responsible. One example was an orthopedic surgeon who was kicked off staff because a drill bit broke during his procedure. That's not his mistake. That's not his fault that a drill bit broke during his procedure. Yet this particular physician took it very personally. It was a black mark on a long and good career. He took it hard. And I want everyone in this room to realize that these are games that the hospital plays. It's not something that's a commentary on what kind of professional you are, how good a doctor you are. It's purely economics, politics. Hospitals go to seminars to learn how to do this, to learn how to destroy doctors. They go to the nicest hotels in the United States, like the Breakers in West Palm Beach, Florida, or the Biltmore in Arizona. And they have seminars in the morning by attorneys who teach them how to destroy doctors. I'm not making this up. And then in the afternoon, they go out, if it's Florida, they go out to the beach and have some, volleyball and some good times and then drinks and so on. And the next morning, it's more instruction on how to destroy doctors. To the point where we recognize the different tactics that are used around the country. We recognize the tricks. One is to claim that a doctor threw something at somebody. And there's a nurse there who witnessed it. The doctor threw a chart at a nurse. In one case, the physician, she had her young child there in the room. It was a woman physician. She said, I've never thrown anything like that at anybody. There's a nurse claiming that she threw a chart at the nurse, and they're using that against her. They call her disruptive. They're moving against her privileges. You will see all sorts of diabolical tactics. Some of the claims are designed to spark a reaction in a layperson, to spark a reaction in a court, as though it's outrageous, like operating on the wrong artery. Or the most classic example that they used against the doctor was that he did heart surgery without anesthesia. Immediately there's an emotional reaction to that, oh my gosh, you just got to get that guy off staff immediately. That's not what he did. It wasn't the way it was described. But the hospital will dress these things up in a clever way to make it difficult when the case does get into a legal proceeding to defend himself because it has such a reaction on the court. We are learning how to defend these cases. We are developing our own tactics, which are above board, not deceitful like the hospital. And we are educating courts. One thing I did in a case that came out of North Carolina, case of Dr. Shinoy. He's been a longtime AAPS member. I've never met him, but we got the call from his attorney that he was in litigation over sham peer review. Sure enough, he's been a good member for a long time. It's an important case. He had spoken out at one of the internal hospital meetings, and he had criticized the administration, and that resulted in his exclusion from the hospital to the point where the hospital said, not only are you excluded as a doctor, you're not allowed to come here as a patient either. These are nasty people we're dealing with. Well, what's the problem with that? I mean, what's a way to counter that when a hospital takes that kind of position? Yeah, go ahead. Yeah, that's right. These hospitals are 501c3 organizations. They're nonprofit organizations. They don't pay taxes. that comes with it a certain obligation to serve the public good. Now, many of us in this room were supporters of individual freedom. Many of us would defend the right of a private company to do whatever it wants, to hire and fire employees as it sees fit. Okay, that's fine. These hospitals are not just private corporations. These are 501c3 organizations set up for the public good that don't pay taxes. They're like public parks. Most of us in this room would have a problem with a park ranger going around and saying, you get out of this park now. I don't like you. I don't like the way you part your hair. Get out. No, it's a public park. And hospitals are there for the public good. So I've started making that argument in court. And as I make that argument, I point out that this organization set up for the public good is paying its executives millions of dollars a year in salaries. I mean, what is going on here? This is like a public school here that's paying its principal $5 million a year in salary. It's set up for the public good. It doesn't pay taxes, and they're paying these kind of salaries. There's something that's not right here. And in the case of Dr. Shenoy, he spoke out against how that administration was being run. Once he did that, you've got people in the administration who are making these grossly inflated salaries. And I said to the court, it would have been safer for Dr. Shenoy to jump in front of a moving train than to jeopardize the salaries that these administrators are paying themselves. Because as he spoke out, if that got up to the board and the board let some of these administrators go, they're not going to get another job paying them millions of dollars. They're going to do whatever they can to protect their gravy train, and they did it by excluding Dr. Shenoy. So I submitted that brief to the court. That's in the Fourth Circuit. It's an amicus brief, friend of the court brief coming from AAPS. Hospital bar protested vigorously. Said, don't look at this brief, don't accept this brief. They don't have a right to file this brief, et cetera, et cetera. Court looked at our brief, and the court accepted our brief. And now that's scheduled for oral argument next month in March. And I think the Fourth Circuit is going to take a look at this. That's a federal appellate court, Fourth Circuit. There are 13 circuits around the country. And they're going to wonder why hospitals have so little accountability, why they're paying themselves this kind of money, and why they retaliate in this way against the doctor who has merely criticized the administration. I compared the hospital industry to the public school system. Both of them spend about $500 billion a year. Both of them are there for the public good. Both of them avoid paying taxes and stuff. But public schools have all sorts of accountability. There's a publicly elected school board. There's all sorts of transparency. There are public meetings where people who are affected by it can come in, and people who are not affected can come in and ask questions and express concerns. There's debate about it in the newspaper. There's recognition of the right to free speech by teachers and students. Hospital industry, analogous in terms of the money it spends, the taxpayer dollars it spends, responsibility it has none of that accountability. And when there's none of that transparency, there's no one watching it, they're going to try to get away with murder, and they have been. And this is going to get exposed in the court system, and we're going to start to get rulings against it. Okay, the case of John Natale at one of the hospitals that has a terrible track record of sham peer reviews. He was a surgeon, cardiovascular surgeon, cardiothoracic surgeon, who there was a competitor there who didn't like what he was doing and complained and somehow got an investigation against him. And next thing you know, it gets into the U.S. Attorney's Office, and he gets prosecuted, and the jury acquits him for Medicare fraud, which there was no basis for any conviction of Medicare fraud, but he is now sitting in jail on a claim that he made false statements in his operative notes about surgery that he had conducted. And he would dictate his operative notes weeks after the surgery, and he would do it from memory. And they were so determined to get this guy, driven by a competitor, that they went back and compared what he had dictated to the images from the operation, and they have convicted him of a misstatement in his operative notes, and he's sitting in jail right now because of that. To us, that was outrageous. You know, what business is that of the federal government? He was not convicted of Medicare fraud. Why are they even involved in the accuracy of operative notes that were dictated weeks after the surgery? And why is he sitting in jail for that? He contacted us at AAPS. We looked into it. We said, no, that's not the direction we want medicine to go in this country. This has a terrible, chilling effect on the practice of medicine. The result is that doctors are going to be afraid to say anything. They're going to say less rather than more. It's going to take more time away of doctors away from their patients to double-check operative notes and so on. There's no evidence that this caused any harm to the patient. There's no evidence that this affected billing in any way. Often images are taken before there's a second surgery anyway. So we filed an amicus brief. Federal government objected to our filing an amicus brief. They didn't want us in. We filed it anyway. The court looked at it. They said, yeah, come on in. Tell us what's going on here. And I told them, I said, this is Orwellian. This is like newspeak, where the government is going to start to get in there and monitor what people are saying in their operative notes, even though it's not connected to any billing fraud. So that was another case we've handled. We've been busy. We've been doing a lot of amicus briefs to combat this war on doctors, and we want to hear during the Q&A I'll have at the end of my talk, we want to hear some of your comments and concerns of what's going on. There's the case of Dr. Rao in California. He appeared in a movie called Life for Sale. A chance, have any of you in the room seen the movie? It's going back a few years now, Life for Sale. Okay, a few have seen that. That's a hospital where a number of doctors were outraged at how the hospital was being run, and another doctor did a movie about it. And this other doctor asked Dr. Rao to be in the movie. Dr. Rao was in the movie at the beginning, where he just sort of stood in front of the hospital and introduced it. Yeah, this is a hospital where I work. He didn't even say anything bad about the hospital, but the movie was released, it went viral. The administrators didn't like that. You know, they didn't like that. That puts the administrators' jobs in jeopardy, and the administrators are being overpaid at all these hospitals. So they immediately retaliate against doctors for doing things like this, and he was subjected to a sham peer review. That's in the California court system, and again, we wrote a brief and submitted it and said, there's a First Amendment right here at stake. You can't be retaliated against for appearing in a movie. Doctors have free speech rights too. And by the way, if doctors can't speak out about what's going on in hospitals, who is going to speak out? How's the public going to realize, become aware of what's happening in these hospitals? And we've heard stories from our members where they will have a patient in a hospital, and then it will come to the weekend, and the shifts will change, and that patient who was getting better and better all of a sudden starts to get morphine drips, and all of a sudden starts to decline to the point of death. We've heard compelling stories from our members about this. And some of us have had relatives who go into hospital who are elderly, go in with what seems to be a minor problem, and then next thing we learn is the hospital's telling us that patient passed away. If there is wrongdoing, how would anybody know? How would we find out if doctors can't speak out about this? If all the doctors become employees of hospitals and the few independent ones who are left get subjected to sham peer review, if they ever dare criticize administration, how would we even know if this goes on? That's the situation we're looking at. Now with Obamacare and these ACOs, hospitals seem to have greater incentive to bring doctors on as employees. And the existence of the independent physician is vanishing. And that's alarming, because as a patient, if we're in a hospital and we want a second opinion, how can we get a second opinion if there are no independent doctors on staff of that hospital? How can we get a meaningful second opinion? Sure, we can get a second opinion from another employee of the hospital, but that's just going to be what the hospital wants to do with the patient. How do we get a meaningful second opinion? Well, there's legislation that's being considered in Arizona to establish a right of a patient at his own expense to get a second opinion from an independent physician if that person is in a hospital. That would be helpful legislation to require these hospitals that are taking millions of dollars in public money to recognize the right of a patient to get a second opinion from someone who's independent and not an employee of the hospital. Many people are surprised to learn that if they're in a car accident, an ambulance takes them to a hospital, that they probably will not be able to be visited by their own doctor at that hospital, because their own doctor is probably not on staff at the hospital that the ambulance driver takes them to. And so their own primary care doctor is not going to be able to visit them and write orders for them at that hospital. They're going to have all their orders written by employees of that hospital. That shocks a lot of people to hear. It shocked me when I learned that a patient does not have the right to be seen by his own primary care physician at a hospital that's publicly funded and taxpayer funded and so on. Okay, the hospital bar has been so aggressive in this stuff that when one of our physicians did win a case out in California, the hospital bar didn't like the decision. They then filed a special motion to ask the court to depublish the decision. I have never seen that as an attorney. In all my years of practice, the other side being so aggressive and unfair that they ask a court to depublish a decision because they don't want the precedent to become known out there. So we went in there and we opposed that attempt to depublish the decision, but it illustrates what we're up against. And I can tell you as a litigator, I litigate against a lot of different industries and people over the years. I have never seen attorneys who are so difficult to deal with as hospital attorneys. I don't know what the mindset is. They take on the personality and character of their client, I guess. They are the worst attorneys to deal with. Common courtesies, they refuse. Refuse to consent to anything. And here's what you have to do, and then I'll open it up to a few questions. If you are subjected to sham peer review, if you see the clouds forming, first of all, think about getting out of that hospital, but be careful. Because if you get out after an investigation has started, that becomes a data bank entry against you. And I've heard from doctors who have resigned from hospitals not even knowing there was any investigation. And they got a data bank entry because the hospital claimed that they were investigating the doctor but had not told her yet. They sent something to the data bank. How unfair is that? If the investigation is started, you have to think about litigation. And you have to think about doing it sooner rather than later to level the playing field, because you're not going to get a fair hearing in that hospital. And it's only the presence of a lawsuit that goes on at the same time that is going to cause the hospital to start to provide some level of procedural fairness. In one case, there was the internal peer review hearing, and I went in for the AAPS member, went into court just as this hearing was starting internally, and I got a federal court order enjoining the hospital from reporting anything to the National Practitioner Data Bank until the court has a chance to look at it. That's unusual, but now that precedent is set, and now other people can get that too, and now we've had another victory like that based on this precedent. That's the way the law works. When you set a principle in court, you can then use that in other cases. So if a peer review is starting against you, consider going into court right away to get a court injunction prohibiting the hospital from filing any entry with the National Practitioner Databank. But even in that case, that alone wasn't enough, because as the internal peer review started going, then I asked to call key witnesses at the hospital who had signed a summary suspension letter, and the hospital said, no, we're not going to provide those witnesses to you. The next day, I filed something with the court, telling them what they were doing. They weren't even providing me the key witnesses in the, who signed the summary suspension letter in the internal hearing. And the day after that, literally that quickly, I heard from the hospital, just because I had filed those papers, and they knew a judge was going to look at it, they said, you know what, we've reconsidered. We will provide those witnesses to you. And you want to go in with that internal hearing and get those witnesses to testify under oath as quickly as possible, before they can take a lot of time getting their story, making up some story and checking it with each other. You want to call those witnesses as soon as possible and get them under oath, because an internal peer review hearing in a hospital, that's all under oath, and that can be used in court. And so the quicker you can get that testimony down, the better it will be, because it doesn't give them time to make up a story and check their story with each other. Interestingly, in those internal hearings, some of the best testimony is from the lowest level employees, because they have the least to lose, and they will be candid, more candid in their testimony than the people higher up. Because people higher up, they have $1 million to lose. They have no problem with lying at all. But the lower ones, they're not making enough. It's not worth it to them to stick their neck out to the hospital. So in one of these internal hearings, after we got all these denials and stories by the people higher up, and we got the minutes from the MEC meeting that they had changed, they did not reflect what the real meeting was like, we saw inconsistencies, I examined a lower level employee, and she volunteered. She said, you know what? These meetings are tape recorded. We have tape recordings of these meetings that the hospital had not turned over. She volunteered that. And I said, turn over those tape recordings. And 2 months later, I'm still waiting for those tape recordings. But I got it under oath that they exist. And if they don't turn it over, that's not going to be good for them either. I just go into court and say, you know what, they got tape recordings, they're not turning over. Wouldn't you like to hear them, Your Honor? Yeah. Yeah, I mean, yeah, it sparks my interest. I would like to hear. So to me, the medical boards are a threat. The federal government's a threat, and I'll be talking about those issues later tonight at the dinner. But honestly, hospitals are right up there as #1 threat to the practice of medicine. I'm sure many in this room have become hospital employees, and I understand that. But those who are independent, you see the pressure, you see the tricks to keep you out. They will pull all sorts of tricks to keep independent physicians off staff. One trick that happened to an AAPS member is the hospital said, well, we're not going to renew your privileges unless you get someone to provide backup call for you. Well, it's never been a problem. He says, fine, I'll call around to get someone, but as he tries to get other people to provide backup call for him, none of the hospitals will provide him backup call. So this is another tactic to get rid of the independent physicians and get them off staff. Say, well, you need backup call. And then he can't, all the other hospital employees, all the ones who are hospital employees won't provide him backup call. So these are the things I'm sure they learn in their seminars. It's good to get a copy of the bylaws. You'll see some of their tricks right in your medical staff bylaws. This is how big it is. I was looking through one this morning. Check out this little trick. For changes to the bylaws, if they're proposed by a physician on the medical staff, then an amendment to the bylaws can be made by a 2/3 vote of the active medical staff member. Next paragraph. If the amendment to the bylaws, medical staff bylaws, is proposed by the governing body, that's the administration. If administration proposes an amendment to the bylaws, it need only be approved by a majority vote of the doctors who are on staff. So if an amendment to the bylaws is proposed by a doctor, it takes 2/3 to approve it, to change the bylaws, but if it's proposed by administration, it only takes 50% to approve the change. Stuff like that is all through these medical staff bylaws. And as I say, there's seminars to train administrators how to do this. Okay, well, I'll be here all day. I'm going to speak again tonight. Appreciate your support of AAPS. It's through your support that we're able to file these amicus briefs and develop these tactics to defend the practice of medicine. Thank you very much.